Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode of the series, we'll take a look at the judicial complaint process in the state of Massachusetts. When I filed the complaint against Superior Court Judge David Ricciardone, this is what I received in reply. A letter addressed to someone else and referencing a different judge. The evidence I laid before the commission reveals a clear and consistent pattern of unethical conduct, procedural violations, and a blatant disregard for the law, all orchestrated by a sitting state court judge. This disturbing series of events began on the very first day of the arraignment. The judge exhibited favoritism by appointing an attorney who was not listed on the designated roster for appointed counsel, a direct violation of Supreme Court Rule 107. This rule explicitly mandates that such appointments be duly noted on the docket, a requirement blatantly ignored in this case. The second anomaly arose during the scheduling of a bail review hearing orchestrated by the specially appointed counsel and set to be heard by the very judge who did the arraignment and made the special appointment. The third issue revolved around a motion for funds submitted by the specially appointed counsel to the same judge who appointed her. While counsel had previously filed 2 motions for funds that adhered to the legal standards, this particular motion to the appointing judge lacked references to the law or required standards. Instead, it simply requested funds, a request granted by the judge without the necessary formalities mandated by law. The fourth issue centers on the transfer of the defendant to a jail where an alleged victim from a previously dismissed case was employed. It's crucial to note that this alleged victim was involved in a relationship with the defendant's spouse. Despite the judge being aware of this delicate situation, he ordered the transfer, a decision that could have jeopardized the defendant's safety and well-being. The fifth issue raises serious concerns about procedural violations and conflicts of interest. The judge conducted a lobby conference without the defendant, a clear infringement on the accused's right to be present at all critical stages of the proceedings. During this lobby, defense counsel openly acknowledged a conflict of interest, stating her personal connection as a dog owner with the alleged crime involved her client kicking a dog. Shockingly, the judge failed to address this obvious conflict. Furthermore, the judge allowed defense counsel to propose a false history category level for the defendant, deviating significantly from the correct level. Astonishingly, the judge adopted this inaccurate level, asserting that sentencing guidelines are merely a guide. Additionally, when defense counsel referenced the defendant's record from years prior to suggest drug-related factors, the judge failed to verify the accuracy of this claim, adopting it as truth without inquiry. Most egregiously, the judge permitted defense counsel, whom he personally appointed, to deceptively use her own suppressed evidence against her client. This distorted representation contradicted the facts outlined in her own sworn affidavit, further highlighting a blatant manipulation of the proceedings. The sixth issue casts a shadow on the judge's impartiality and reveals a blatant disregard for potential coercion tactics. On the record, it was disclosed that the defendant was confronted by his wife's lover upon being transferred to the jail where the man worked. an individual who was also the alleged victim of a dismissed case. Despite the clear conflict of interest and the potential influence on the proceedings, the judge turned a blind eye to these critical details. During the lobby conference, the prosecutor persisted in pushing for the involvement of this unrelated alleged victim, intertwining the dismissed case's facts with the present ones. This manipulation aimed at unduly influencing the court's perception and subsequently the outcome of the lobby. Shockingly, the judge failed to address this alarming issue, neglecting to consider the potential impact of the transfer and confrontation on coercing the defendant into pleading guilty out of fear. The seventh issue exposes a troubling sequence of dishonesty by the judge in his interactions with the defendant. Following the previous ethical violations, the judge falsely claimed to the defendant upon his arrival in court that he was persuaded to follow guidelines proposing a 2.5-year sentence. However, crucially, the judge never explained the guidelines' nature or calculations, omitting the fact that he was adopting a false history category level proposed by the defense counsel he had previously specially appointed. And when the judge realized the defendant's lack of understanding about the guidelines, he abandoned them entirely, along with Procedural Rule 12 governing pleas. In open court, he proceeded to lobby the terms of probation directly with the defendant, bypassing defense counsel and the prosecutor. This flagrant violation of Rule 12 involved ex parte communications, disregarding due process safeguards for constitutional rights and state laws. Despite prior assertions of compliance with guidelines, the judge, through direct negotiations with the defendant, applied the committed sentence to the lesser of the indictments, violating established guidelines. This act, coupled with deception, amounts to a clear case of fraud by the judge. The irrefutable evidence exposes this violation of the law, rendering the judge's actions under color of law. Shockingly, both the defense counsel and prosecutor observed this unlawful breach of ethics and law, choosing not to intervene. The eighth issue unveils a disturbing incident where an altered document was presented as evidence in a court of law. The defense counsel acquired her client's signature on a document titled Waiver of Rights. Yet this document was a distorted version of the original. It appeared wavy and blurred, a far cry from the standard expected for a document that waives a citizen's constitutional rights in a court of law. What makes this situation even more egregious is the judge's failure to reprimand the defense counsel for submitting this altered document. Instead of demanding a proper document that adheres to legal standards, the judge, after inspecting the document himself, personally presented the distorted version to the defendant. Astonishingly, he proceeded to ask the defendant if he had read and understood the document, despite its clear unintelligibility. This failure to address such blatant violations raises serious concerns about the integrity of the legal proceedings. The ninth issue brings to light deeply concerning comments made by the judge, simultaneously violating the defendant's constitutional rights, along with procedural rules and laws of the state of Massachusetts. In addressing the alleged victim, the judge made disturbing remarks, such as expressing, quote, "I can only imagine if I, or most average people were in your position. In asserting that, quote, the law categorizes offenses. He went on to say, quote, you were violated, and made the troubling claim that, quote, people take difficult to understand steps to inflict pain that goes beyond the basics. Particularly alarming was his statement that, quote, some very smart individuals created the calculations based on guidelines that judges historically use to impose a proper or a fair sentence. Followed by, quote, I'm basically following traditional jurisprudence here. These comments are especially troubling given that the judge had already departed from the guidelines and violated Rule 12 procedure governing pleas. His remarks, including statements about the imperfection of justice as he administers it daily, and attributing the defendant's actions to drug addiction without proper inquiry, raises serious questions about his commitment to a fair and impartial legal process. The most unsettling comment came when he told the alleged victim, quote, this is not just a violation of your home, but it was a violation of trust, all the while engaging in deception and dishonesty, breaching the trust placed in him as a judge in the Massachusetts Superior Court. The 10th issue sheds light on the comments made by the judge to the unrelated alleged victim of a dismissed case, who happens to be the defendant's wife's lover and works at the jail where the defendant had recently been transferred. The judge, while violating the defendant's rights and engaging in fraudulent court proceedings, offered consolation to this individual. He expressed sentiments such as, quote, I'm not insensitive to what you underwent, and mentioned, quote, I sort of heard some of the facts involved. These comments are deeply troubling, especially in the context of the judge's demonstrated indifference to the rights, safety, and trust of the defendant within the judicial process. The 11th issue highlights the judge's inappropriate legal advice to the defendant's wife's lover, who works at the jail where the judge recently ordered the defendant's transfer. This individual, also an alleged victim of dismissed charges, sought a stay-away order through the prosecutor, well aware that the court lacked the authority to grant such an order. Despite acknowledging this limitation, the judge, in a highly irregular move, provided legal advice from the bench to the unrelated alleged victim, stating, quote, if he has a basis for a restraining order or 258E order, that's something he can explore. This situation is deeply concerning, as the judge is offering legal advice to an unrelated victim while simultaneously violating the defendant's rights, with both defense counsel and prosecutor complicit in these actions. The defendant, in desperate need of proper legal guidance, found no such support from those involved in the proceedings, further highlighting the egregious violations of his rights. The evidence supporting these claims is both overwhelming and indisputable. The 12th issue revolves around the judge's sentencing decision. Despite assuring the defendant that he was adhering to traditional guidelines and confirming the defendant's understanding, the judge sentenced the defendant to the committed sentence on count 2 larceny. This sentence, not aligned with established sentencing guidelines, was delivered without a restitution hearing to ascertain the specifics of the stolen property or its confirmed value. Consequently, the defendant remains uninformed about the nature of his punishment and faces potential challenges regarding probation violations in the future. The judge's dishonesty and disregard for rules of procedure and state laws are evident, constituting clear, unethical behavior. The evidence supporting these claims is unequivocal. The 13th issue revolves around the judge's handling of the defendant's post-conviction Rule 30 motion for a new trial. The judge, in violation of Rule 30 procedure, invited the defendant to a non-evidentiary hearing without the required 30 days notice, scheduling it for the morning after the defendant received the Commonwealth's brief in opposition to the motion. According to the evidence, the Commonwealth was legally obligated to support the defendant's motion in the interest of justice. Despite this, the judge denied the motion without referencing the Commonwealth's brief or conducting a hearing, especially when the defendant declined the impromptu hearing without any notice. Moreover, the judge's rationale for the denial is fraudulent, given the undeniable evidence of dishonesty and deception in the judge's interactions with the defendant, which is well documented and apparent. The final issue underscores the judge's failure to address the undeniable evidence of his deception and procedural violations, as clearly presented in the court records. Instead of taking corrective action as mandated by law to rectify the injustice, the judge knowingly denied the defendant's motion, perpetuating further acts of fraud. In a follow-up call to the Commission on Judicial Conduct, they reluctantly admitted their blunder in addressing someone else's letter to me. However, their audacity reached new heights when they insisted that the misdirected paragraph was, in fact, related to my complaint. Undeterred, I fired back with a second letter, a reminder that judges are not granted a magical discretion pass to flout rules, deceive defendants, and subvert constitutional rights. Their response to my call, a regurgitation of the initial retracted letter, arrived shortly after I dispatched my follow-up. This is the letter. Unsurprisingly, the Commission maintained their ominous silence on my second letter, a direct plea for the proper docketing of my complaint. I'm your host, William Toppi. Brace yourselves for the next episode where we dissect the clemency process and take a look at the path citizens navigate to petition the governor for a pardon. Remember, our pursuit of justice begins with you.